The Democracy That Delivers podcast is brought to you today by the Anti-Corruption and Governance Center at SIPE. This is the podcast where we talk about corruption in its many forms. And now to your host.
Hello, everybody. I'm Frank Brown, the director of the Anti-Corruption and Governance Center here at SIPE. And I want to welcome you to this week's podcast, which is all about the Foreign Extortion Prevention Act, a law that was recently passed in late December of 2023. The Foreign Extortion Prevention Act, or FEPA as we call it, effectively makes it a crime for a foreign official to demand or accept a bribe from an American company or any company with a U.S. nexus, for example, listed on a U.S. stock exchange. It is arguably the most sweeping and consequential foreign bribery law in nearly half a century. Today, we're joined by Tom Firestone and Scott Greytak, both of whom helped author and advocate for the bill. And they're here to discuss this historic piece of legislation and its potential to help root out foreign corruption. Additionally, they will speak to who the law covers and the necessary steps that must be taken in order to enforce it. They'll also be talking about what the potential implications are for state-owned enterprises. With that, I wanted to introduce Scott and Tom.
I appreciate it, Frank, and great to be able to chat with y'all about this. So I'm the Director of Advocacy for the U.S. branch of Transparency International. Transparency International, or TI, is the oldest and largest anti-corruption organization in the world. We are in about 120 different countries. And, you know, we came to this idea thanks to the thought leadership of Tom and the folks at the Helsinki Commission on the Hill. The initial version of FEPA was introduced in late 2019, and understanding the potential impact and scope of this law, we took it up to take a look at that draft, to use what we have in-house as our anti-corruption policy lab to do some additional research, some changes to the bill, and basically for the last 4 years had been leading the civil society campaign in support of it. And trying to get it through Congress and across the president's desk. And I can go into a bit more detail on what that process involved, but we were building coalitions across the aisle, recruiting and engaging leads in both chambers to prioritize the bill, working it through that ugly sausage-making process to keep it a priority, engaging the administration, getting some additional materials that tell the story about why this law is needed, especially from some of our chapters in some of the most highly corrupt environments around the world, and how this could really make a difference. Legal research into how, as you mentioned, this could be enforced as a matter of not only law, but practically how this is going to be enforced by the U.S. government. And then making sure, as we're trying to do here and elsewhere, that folks know about this law and that they're able to maximize it, and that the U.S. government implements it robustly and gets the biggest bang for its buck, because we really do believe that it is the most important foreign anti-bribery law since the Foreign Corrupt Practices Act.
Super, Scott. So that's a great overview of how the bill became a law, and we'll touch upon this later in the podcast, what we can expect in the months and years to come. I wanted to give Tom Firestone a chance to introduce himself, to talk about what he does for a living, and what sparked him to, if as I understand it, be the first person to take a whack at drafting the bill that became FEPA. Tom?
Thanks, Frank. I am a partner at the international law firm Squire Patton Boggs. I've been in the private sector for many years. Before that, I was a federal prosecutor in the Eastern District of New York, and I also worked as the DOJ representative for the U.S. Embassy in Moscow. In private practice, a lot of my work has involved representing companies in FCPA investigations, and I see what a great tool the FCPA is in promoting anti-corruption around the world. It attempts to choke off the supply side of bribery, and it allows companies that know how to use it to resist bribe demands by saying, look, we can't make this payment. It's a crime under the U.S. law. We could be prosecuted. And I think it's great, but it only addressed the supply side. Meanwhile, I saw all these cases where companies were essentially being extorted by foreign government officials. And it occurred to me, U.S. government efforts were really disbalanced in this regard. They were focused almost exclusively on the supply side, but every bribe situation requires a bribe giver and a bribe taker. we were focusing only on the bribe givers. And it seemed to me that the US government efforts would be more effective if they also went after the bribe takers, and US companies' ability to resist bribe demands would be much stronger if they could say to government officials who ask them for bribes, we can't pay because it's a crime under US law, we could be prosecuted. And now they can say in something like this would allow them to say, and you can be also. So I wrote an article in the end of 2018, basically advocating for this. And Scott and I think Paul Massaro, Gary got in touch relatively quickly thereafter. I think that maybe I did the first draft of the law, and Scott was very kind in crediting me with the thought leadership. And then after that, it was really these guys, Scott and Transparency, that ran with it and got it through the legislative process. Something I saw the problems on the ground and saw the need for a fix, and these guys actually made the fix happen. So it was a great collaboration, and I think it's a very significant achievement, which will reduce the amount of corruption around the world and protect U.S. companies.
So this is a point at which I wanted to just very quickly talk about what this means for SIPE and other mid-sized NGOs like SIPE that focus on reducing corruption overseas, and why this is so significant. Because, Tom, as you pointed out, for years we've had the Foreign Corrupt Practices Act to talk about, it often in abstract terms, because we work in countries where, to be honest, most people have no fear of ever being investigated or prosecuted under the Foreign Corrupt Practices Act. But what they may fear is potential, not even investigation or prosecution, but just potentially being identified as vulnerable to this piece of legislation in a very personal way. And that, I'm hoping, will have a chilling effect among those public officials in emerging market where corruption is rampant, and it'll give them pause, at least to perhaps not ultimately to seek the bribe, but to do it in a less direct, less damaging, less sort of corrosive way to overall society. And so setting that up, like the relevance of, for an NGO like SIPE, what that means for us, I wanted to ask you, in practical terms, given the extraordinary scope of this law and what sounds to me like just a blank slate globally, in practical terms, what do you expect to happen in the coming months and say 1 or 2 years? Like what needs to happen to make this truly effective?
Well, I would say the first thing that needs to happen. Look, DOJ is going to take them some time to put cases together, to do a thorough investigation, to charge a foreign government official is not going to be a simple task for DOJ prosecutors. So it's going to take time to put those cases together, and we can't expect big cases within 2 to 3 months. What we can expect in the near term is a consciousness raising effort. The government getting the word out, Transparency International getting the word out, SIPE getting the word out. We are advising all of our clients to tell their people on the ground in high risk markets about this, because when the word gets out, that will hopefully have a deterrent effect. So I think that's what we need to expect in the immediate future is consciousness raising. Then hopefully we'll see some cases. And I just want to make the point that we should look for cases not just from DOJ, because let's face it, in a lot of cases, it's going to be difficult for them to make the charges. If they do make the charges, it'll be difficult to extradite somebody to the US to face justice. What this will hopefully do is give a real push to foreign governments to crack down on their own domestic corrupt officials, because they're presumably not going to want these cases to be adjudicated in U.S. courts for a variety of reasons. So if they know about this law, they may crack down domestically. So I think it'll have a ripple effect, a force multiplier, which, as we say, as we've been saying, will hopefully reduce the amount of corruption overall. But to go back to your question, short term, I think the main thing is getting the word out about this law.
And Tom, just to dive in very quickly before I go to Scott, why could you explain to me and the listeners why would a foreign government be so concerned about the adjudication of one of their officials who's solicited a bribe? Like why would they care?
Well, because that official probably did not take all the money himself. He probably shared the proceeds with higher ups in the government. And if that person is arrested and extradited to the US and starts to cooperate to get a lesser sentence, or goes to trial, at which trial the US government's going to present all its evidence about all the circumstances relating to this, it may reveal very unpleasant facts about other people in that home government, and they may not want that to happen. And so one thing, hopefully what they'll do is just instruct their own officials, don't ask for bribes, period. And I just want to say, it's not just US companies. There it also, includes issuers, which could be foreign companies, which sell shares on US stock exchanges. So hopefully they will just, cut down on bribe demands in the first place. But when there are bribe demands, hopefully this will give them a real incentive to prosecute those cases domestically. And those public, cases should deter future bribe demands in those foreign countries.
Okay. And just to sort of finish the thought, like if we look at what happened in Malaysia with the fall of a government after the 1MDB scandal, like that would then be the sort of consequences that we in principle could expect from this piece of legislation, this law. Like if you sort of keep pulling
Well,
on the
look,
thread.
every situation
Go ahead.
Yeah, every situation is going to be different, and it's going to, maybe the whole case will end with a procurement official at some, state-owned hospital or something. That is going to be some cases, and then other cases, it's going to go to higher levels in the government. So, and that will we know what happens when corruption is exposed in foreign countries. Sometimes it leads to mass demonstrations, changes in government. So, I think that this, as I say, it'll have a ripple effect that we can't foresee right now, but I think what we can foresee right now is the overall effect of this law is going to be less corruption throughout the world.
Okay. Thank you. And Scott, so I wanted to turn to you to get a sense in very practical terms. If you scan the globe, looking at all the Transparency International chapters, some of which are quite small, 5, 10 people, some of which are formidable and big players in their respective countries. If you look at that massive network of folks who in principle could use this law, use FEPA to further their aim to reduce corruption in their countries, what do you see as the practical steps to giving them the tools necessary to do that? Or is that a misconception? Is that not, am I way like massively overreading the potential impact of FEPA?
No, I don't think you are at all. I mean, just yesterday, Transparency International released its annual Corruption Perceptions Index, which gauges perceptions of corruption in 180 countries and territories around the world. Two-thirds of the countries, so 120 countries out of 180, according to that scale, are dealing with serious levels of corruption in their home countries. So, consider this: there are entire organizations that are set up in order to evaluate and submit for potential sanctions corrupt officials. So there's an organization here in DC that we partner with that supported FEPA, where one of the main things that they do is work through their networks to build cases against foreign officials and others who engage in significant acts of corruption. They then send that to the US government, and the US government decides whether or not to impose, visa bans or freezing of those officials' assets in the United States. And this is a extremely large and productive and successful network. Um, there are a few more jurisdictional requirements, like Tom mentioned. In order to get a FEPA violation, this has to involve an American or American company or any company listed on a US stock exchange, et cetera. But that same level of infrastructure and network and responsivity that you have seen build up, this cottage industry around our anti-corruption sanctioning program, we hope can be built up around FEPA. So, pick your point on the globe, pick your parade of horrible of what these corrupt officials are engaging in and how it hurts their people. But that also means that you have so many stakeholders who can provide evidence to justify a FEPA violation and be able to present that case to the US government. So if you are a competitor of a company, if you are in the supply chain working with a company that has been solicited for bribes, if you are the foreign official who is competing with one of the corrupt officials who is demanding a bribe, if you are their underling or their supervisor, obviously, if you are a whistleblower or a journalist or a civil society activist who is watchdogging this sort of behavior, there are so many opportunities for those tipsters to be able to report that information and be able to bring these cases to the DOJ. One thing to really drive home here for international listeners that Tom alluded to, we got a question from our chapter in Sweden yesterday about what this law means. And it's really, really important to say, yes, this, at first blush, FEPA is designed to protect Americans who are working abroad. But because it also protects any company that is listed on a US stock exchange, so any company on the NASDAQ or the New York Stock Exchange. So we said to our Sweden chapter, if Ericsson or Volvo is doing business anywhere in the world and their employees are solicited for a bribe, they would be protected by FEPA, and that corrupt foreign official would be subject to criminal sanctioning by the US government. So that really kicks open the door on potential enforcement and scope of this law.
So I wanted to very quickly, Scott, pick up on one thing you mentioned and then turn to you, Tom, for a readout on what this means for the business community and their engagement in the passage of FEPA. So, Scott, I've heard you talk in the past about a FEPA pipeline. And I think what you're talking about, and correct me if I'm wrong, is that you mean ways in which to highlight and amplify the incentives for folks to report FEPA violations. And in so doing, make it easier for them to sort of give a nudge to that incident that they observed and make it easier for DOJ to gather these complaints and allegations in a way that would be actionable. Could you, a couple words very briefly, because we don't have too much time, but what are you thinking around a FEPA pipeline? What might that be?
I mean, fortunately, we have a model around the global Magnitsky sanctioning program that has been in place for almost a decade at this point. But there is an existing pipeline. Transparency International, we work with collaboration with journalists around the world with our chapters, where we say we believe that these officials in these countries have met the evidentiary threshold that they should be sanctioned for significant acts of corruption. And so we work with the journalists who are on the ground, collecting that evidence, collecting those stories. We package it up, working with teams of attorneys who know how the global Magnitsky sanctions in the US work. And then there are folks who basically have relationships with the US government where they know where to send this information. They know how to advocate on its behalf. They know how to push for those sanctions to actually happen. We want to see that same kind of infrastructure be built up around FEPA. TI has the chapter network. We have relationships with the activists, the whistleblowers, the folks on the ground, the journalists who could help develop these cases. The business community can be essential in working with those folks. The US government, through its embassy and its missions in those countries, can help out as well. Let's get folks the guidance and the standards that they need to know when a FEPA violation has occurred. And let's create that pipeline to bring that to the US government to tee up these potential cases for them to investigate and enforce.
And that's a real call to action, I think, to NGOs like SIPE, especially SIPE, because we work with those on the front lines of these violations, the businesses. So it sounds like there's a lot of work to be done, but tremendous potential. So, Tom, I wanted to ask you a little bit about the role of the business community in supporting FEPA, getting it through, because I know in the past there have been elements of the business community that have been opposed to anti-corruption laws. For example, Foreign Corrupt Practices Act, the Corporate Transparency Act, which was the U.S. beneficial ownership law. But in this instance, I get the sense it perhaps was somewhat different. So could you describe that and explain why it was different?
Well, Scott worked more with the business community in terms of getting their support for the legislation, but I can just say this is something the business community should be interested in. It's designed to protect them, and I think that's a large part of the reason it was different. They Again, this was really designed to level the playing field for them. They are the only ones who are being investigated for bribe giving. Now, the source of the demand is also going to be a subject of investigation, and the law recognizes that in certain cases, and we got to be careful to limit it to certain because it's not always the case, the company is really a victim of extortion rather than a willing bribe giver. This law recognizes that. Now, of course, there are situations where there are going to be companies who probably were willing bribe givers are going to try to use FEPA to characterize themselves as victims. And there are going to be other cases where, they're both. They're willing bribe givers and they're victims of extortion at the same time. And legally, the two can coexist. But this will create a new class of companies that are subjects of FCPA investigations that are viewed appropriately by the US government as victims. And so I think they should support it. And again, as I keep coming back to, the whole point of this is to deter bribe demands on them so that they can operate in a
Mhm.
competitive, fair, competitive market around the world.
Yeah, yeah.
And let me just say that, like yesterday, Representative Joe Wilson, South Carolina, he was the House of Representatives lead Republican behind FEPA. He is, without him, this law could have never been included in the national defense bill the way that it was. It would have never gotten over the finish line. Um, and he made a really good point that I think any of us who work in Washington constantly know is happening, but we forget about because of how the media portrays this, that when folks are working together, you don't get a lot of media attention on that. But it's only when there are differences, conflict drives narrative, et cetera, et cetera. And sure, there are places where the business community and CSOs and whatnot will diverge in interests, but it would not have been possible to get FEPA over the finish line were it not for the support of the US Chamber. The relationship that we and others in this coalition built through working on this for the past 4 years was a genuine, principle based, an excellent example of what the media would make you think is strange bedfellows coming together to get something important done. But they have phenomenal expertise and resources and networks to be able to advocate for bills like this. Um, I know that when folks see these communities together, because of all that partisanship out there, they tend to think it's surprising. It's not surprising. And in fact, it's absolutely necessary if we're going to win the larger fight. And so we were thrilled to be able to work with the US Chamber and other business group partners and being able to get FEPA over the finish line. They were absolutely essential to getting this done. And as you say, Frank, they are going to be the eyes and ears on the front lines in so many of these countries around the world dealing in corrupt environments. We can hopefully count on them to be able to be the canaries in the coal mine raising the flag about potential FEPA violations so we can bring those officials to justice.
And I just want to add on that one point, and I think this goes to why SIPE's work is so important. Is that the U.S. government does a lot, commits a lot of resources to trying to promote rule of law around the world, ranging from technical assistance programs, training of judges, all the way to military actions. But in my experience working on these issues, the business community is one of the best and probably the most effective mechanism for promoting rule of law around the world. When US businesses go into a country, ethical US businesses, they change the environment because they train their local employees on anti corruption. They won't do deals with corrupt business partners on the other side. That's the kind of day to day thing that can change a culture. And so I think supporting the business community when they do this is essential. I know that's what SIPE does, and I think that's what FEPA does.
Thanks, Tom. Thanks, Tom. And yeah, from this podcast, I'm getting my to-do list is growing. Lots of things to take next steps on. I wanted to quickly disclose that SIPE is an affiliate of the U.S. Chamber of Commerce. We get no funding from them, but we're an affiliate, just to put that out there. And then, Scott, very, very quickly, if you could just in a few sentences answer the obvious question that comes from what you laid out as a sort of very logical, rational, comfortable coalition of business and civil society on FEPA. What's next? Is there another piece of anti-corruption legislation or a push that you could see a similar alliance making progress on?
That's a great point. So in 2022, the House of Representatives passed a bill called the Enablers Act that would essentially extend the same anti-money laundering protections that every bank in the United States has to have to those who help facilitate corruption and money laundering. We call those the enablers. These are, folks who tend to be lawyers or accountants, corporate service providers, trust service providers, money managers, the intermediaries who, will be working with corrupt officials and are not required to look into their backgrounds, to do the sorts of due diligence that would let them know that they are being exploited by these corrupt officials in order to move and hide their money overseas, often into the United States. The coalition that came together behind the Enablers Act, and that is being brought together again as we speak, involved law enforcement, religious organizations, faith groups, labor, environmental organizations, conservative foreign policy groups, and domestic anti-corruption groups. It really is another example of across the board folks who can all benefit from accountability and increased transparency in government. And so we're going to be making a real push this year to finally get that bill over the finish line. It has the support of the Biden administration. Again, it was passed by the House. It came within one key vote in the Senate of being made into law. And we think that 2024 is going to be the year that we can finally get enablers done, just like we did with FEPA last year.
So we'll stay tuned for that. That's interesting that there is something on the horizon so concrete. I wanted to go into a bit of a lightning round because we don't have too much time, and I have a bunch more questions. So this question to both of you: if we look at the way the Foreign Corrupt Practices Act, passed way back in 1977, gradually picked up steam, and then was emulated by other governments, the UK Bribery Act, Brazil. I mean, the list goes on. French happened to. Goes on and on, the OECD Working Group on Bribery. So if we look at the way that blossomed and spread geographically and jurisdictionally, is there something in the wings for, could FEPA also experience a similar sort of growth and spreading?
I think it could. A lot of countries already have passive foreign bribery legislation, so it's really a matter of making those statutes active, actually enforcing them. But I do think this will have, as I say, I think it will have a ripple effect. We're not going to have no cases for 25 years like we did with the FCPA, because Scott already talked about the pipeline of cases out there. I think it will have a ripple effect on foreign governments.
And I think what's important, one thing that we've been flagging is, not every FCPA case, but I would be willing to guess the majority of them. There is a bribe giver and the bribe acceptor. And so at the very least, the FCPA enforcement unit in the US government, each of those dozen of cases or so a year that are brought, there should be a corresponding FEPA case involved there. And so we stand to benefit from the robustness of the FCPA enforcement infrastructure that's already out there. And I think that will naturally be able to develop FEPA into something that folks can count on and expect and showcase the benefits of, that we can then take to other governments around the world and say, this isn't some thorny foreign policy diplomatic issue that you have to figure out. The US government is able to do it in these situations, and so you can as well.
Super. That makes perfect sense. So the infrastructure is in place from the FCPA, and that in turn makes this an easier lift in terms of moving it out geographically. So two more very quick questions. State-owned enterprises, for SIPE anyway, are one of the most difficult animals, if you will, to change the behavior of. In other words, these are big companies, typically control vital sectors in a given country, are controlled by definition by government officials, often have priorities and incentives that have nothing to do with the market, everything to do with politics. And it's been very hard to influence their behavior. But I'm wondering, because FEPA criminalizes the bribe soliciting of a foreign official, foreign officials head SOEs by definition, is there an opportunity there? Could this be perhaps not the golden bullet, but some, weaponizable element that we previously haven't had?
I think so. I mean, the state-owned enterprises are not specifically covered by FEPA, but their employees are. And so if there's an investigation of the employee or prosecution of the employee, that's going to open up a whole can of worms about the SOE that they're not going to want to have opened up. So I think, there could be civil litigation, even though they're not covered by FEPA. There are creative prosecutorial theories under which they could be charged with conspiring with the individual bribe-taking employees to violate FEPA. So it should again provide an incentive to SOEs to clean up their acts. Yes.
Tom, so I'm thinking that the FEPA then would cover the employees of state-owned enterprises. Is that right?
Absolutely. FEPA covers employees of state-owned enterprises. It doesn't cover the enterprise itself, but there are all sorts of other ways that legally to get at the enterprise. And there are a million reasons why the enterprise, qua enterprise, is not going to want to have their employees demanding bribes or be prosecuted under this, even if the enterprise itself, the entity that is, cannot be prosecuted.
That's encouraging. So that's yet another thing to put on our to-do list at SIPE to look into. One last question for both of you, whoever's more comfortable answering it, has to do with small and medium-sized enterprises, or SMEs. So these these kinds of businesses around the world are very, very difficult for us to incentivize to put in place anti-corruption compliance programs, much less give less bribes to government officials, just for a whole host of reasons that I won't get into because we don't have too much time. But I'm wondering if you take, for example, a 10 or 20 person business in a place like Moldova that exports and has to engage with the government for various licenses and permits, but doesn't have a person dedicated to anti-corruption compliance, and maybe they have a part-time lawyer and that's it. But how might they use FEPA to push back against an overwhelming environment of bribery and corruption?
Yeah, I mean, and first, I, went on behalf of the State Department to Moldova about a decade ago to work on corruption issues, and one of the strongest assets they have there is the U.S. Embassy, and there is a new law that just came into effect this past month that gives the Secretary of State the authority and the prerogative to designate an anti-corruption officer at each embassy around the world, should they choose. We think that this is exactly the kind of portfolio that that person could have, where in collaboration with the DOJ, once the DOJ has put out guidance about what FEPA means and how companies like that could protect themselves, how cases can be brought against foreign officials, what is needed, that these folks at these such companies can know that they can turn to, if not the civil society groups like Transparency International, but turn to the US government as a source of information and guidance to help make sure that these companies are protected. And I'll tell you, between FEPA and the law that created this authority to designate those officers, you put these two together and you are really realizing the infrastructure to be able to make a difference for those sorts of companies who don't have the internal capacity to prioritize it.
So that's a great way to wrap this podcast up. Scott, to your point, creating the FEPA pipeline, like we need to constantly be looking at new ways to apply it and adapting to the opportunities that present themselves. Because this environment, this is one of the reasons I love so much working in this corruption landscape, is that you're surrounded by innovative people in both good and bad ways. And things are constantly changing. And so if we're on our toes and looking at ways we can adapt FEPA to these different circumstances, it sounds to me like this law has tremendous potential. So I wanted to thank both of you, Scott and Tom, for joining me, for taking the time, but most of all for driving this law forward, because it sounds like a very big deal in our world. So thank you.
Listen and subscribe to SIPE's Democracy That Delivers, wherever you get your podcasts.